Mansion over Hilltop. Thank the Lord for that truth. Just three quick things before Brother Todd comes and helps us tonight. One is next Sunday, back to school Sunday. So have your students here and be praying for our kids as they go back. And we got a little something for you kids to give to you as you go back to school. We want to honor you and pray over you. So keep that in mind. Baptisms. We have a lot of baptisms scheduled. Praise the Lord for that. We're thankful for the souls been saved in the last 8 weeks especially. And so we're going to start working on that, and we'll get you further detail. We've got some that are traveling, so we're just trying to coordinate it all. But want to keep that before you, and we'll certainly let you know and be talking about that a little bit more in future services. And the last thing I want to mention tonight is for our ladies. You can read the details there in the bottom of the bulletin. But August 27th, I'm having a ladies' conference, one-day conference, just a Saturday. Try to mark it off, slot it off on your calendar. I believe it's just the first half of the day. And going over to Tabernacle in Kinston. Tabernacle Free Will Baptist Church in Kinston, North Carolina, for the Diamonds Out of the Dust is the theme, and a women's conference there. Ladies, we want you to be able to be a part of that. It costs only $10, very minimal, and but again, if that is a problem for anybody, you want to bring some guests with you, and they can't swing that, please let us know, and the church wants to help that. Never want anybody not to be able to go and be blessed because of finances. Just keep those things in mind, and we certainly appreciate it. Did any family not receive a booklet and a pen that the ushers were passing out at the beginning? Any family not receive, looks like this right here, back in the mic, looks this right here. Any family, just one per family is good. Great job, guys. They covered everybody. We want to give the remainder of time to Brother Todd. So appreciate him being here with us. He's blessed us. We've enjoyed his fellowship, and so you give him your kind of attention, brother. You come and share with us this evening.
Good evening. We're in North Carolina. We can do better than that. Good evening. Appreciate the opportunity to be here, and trust you had a good afternoon. How many of you believe that God supplies our need? Say amen. How many of you believe that sometimes when we need something, and we might even mention that we need it, that God prepares well ahead of time to prepare that we might need it? You believe that? I mean, if preacher needed something, and God knew that, and God knew he was going to ask for it, or at least mention it, then how many of you believe God could work ahead of time to make sure that happened, right? Well, I don't know if you caught it in his message this morning, but I saw him wiping his forehead with some of these tissues here, and while he was preaching, he said to his wife, he said, we need to get some more handkerchiefs. And lo and behold, I had been to a store, and I had bought some on clearance and had bought 2 boxes of them. And I was thinking, Lord, I don't need but one, and I don't know who else is going to need the other one. But preacher, tonight I've got you a gift, brother, and it is a box of handkerchiefs, 12 of them right here. Come get this, okay? There you go, brother. You're welcome. Listen, if God can do that with a box of handkerchiefs, can He do that with other things as well? Amen. Well, I appreciate you being here tonight, and it's my honor to be here. And I want to share some things with you that I pray will be a blessing with you. Our Free Will Baptist Foundation has been in existence for more than 35 years, and God opened the door for us to be able to go out to our churches and teach our folks on how to be good stewards over that which the Lord has blessed them. And we certainly believe that this information will be beneficial to you. It'll be a little bit of different service tonight, but I want to encourage you to follow along in the book, and I believe that you will find it very beneficial. And at the end, I'm going to try to have a question and answer time, and that way, if you want to write down some questions as we're going through this, I may end up answering it, and if I don't, certainly I will try to do that at the very end. Our Free Will Baptist Foundation partners with Cornerstone Estate Planning in helping people to protect their stuff. And when we talk about estate planning, sometimes people think, well, you got to have a lot of things. Let me start out by that. When I say the word estate,
what comes to your mind when somebody, and I feel like we're family here tonight, but when somebody mentions the word estate, what comes to your mind when I mention that word? Anybody tonight? What is your estate? What is it? Property. Listen, when you give a good answer, you're going to get a teddy bear for a good answer, okay? Who said it? Who said it? Way back here in the back. I'm going to throw this teddy bear, okay? There you go. Have something to give the grandchild. In all sincerity, and that's a very good answer, your estate is your property. It is everything you've got. It is your stuff. Some people think that you've got to have a lot of stuff in order to make preparations. And the misconception is, well, I don't have a lot of stuff, so it doesn't matter. At the end of the day, whether you've got a little or whether you've got a lot, you want to put some things in place to protect that which the Lord has blessed you. Now, this one is not in your book, but I encourage you to write it down in your book. In North Carolina, there are 3 ways that an individual can handle their estate. One is to do nothing. Obviously, we do not believe that that is being a good steward over that which the Lord has blessed you. Dave Ramsey says about 70% of evangelicals have nothing in place to protect their families. Now, why do you think that is? I'm not going to give away a bear, but just what are reasons why you think people do nothing? Why do people not prepare for the future? Anybody? They feel like what they have is not worth it. That's a good answer. They don't like to think about death. So many times, people say, I've heard them say, I tried to talk to my mom and dad about this. They don't want to talk about dying. What about the P word, procrastination? How many of you are procrastinators? And you don't have to raise your hand. I had one man in a church one time, he said, I'll raise my hand later. But we're all procrastinators at some point in time in our life. We put these things off. And of course, we do not believe that that is being a good steward of that which the Lord has blessed us. Because if we do nothing and we don't decide, then who is going to decide for us? The government is. The state of North Carolina is. And so we're going to try to teach you tonight how to keep the government out of your business. But obviously we don't believe that that is the best way to plan your estate. The second way an individual can handle their estate or settle their estate, it is kind of a default option. It is a very common option. It is what is called a will. A will is basically a set of instructions that we leave for those that are left behind. The weakness of a will is twofold. Number one is a judge has the legal authority to alter your will after you die. If someone were to contest your will or to protest provisions within your will, then a judge has the legal authority to alter your will to satisfy all parties involved and possibly the very desires that you had hoped would happen might not end up happening. I had a lady at Garner Free Will Baptist Church that came to me after the service the night that I was there. And she said to me, my cousin had a will. She said I was the personal representative. It used to be called executor. Now it's called the personal representative. She said I was the personal representative. She said she just got a daughter, but the daughter's faced some physical problems and didn't really feel like that she could settle the estate. She said, and everything was going to go to meet the needs of her daughter. And she said, after she died, she said there was a distant family member, not even somebody in the will, that didn't think that that daughter should be getting all of that estate because of her physical handicaps, and contested the will. And she said, this is what she told me. She said, it's been 3.5 years. She said, we've spent $70,000, and I can't even touch what I need to touch in order to take care of my cousin. Now, those are extreme situations, but the second weakness with the will is not only can someone contest the will or protest provisions within the will, but also whether you write your own will or whether the most expensive attorney writes your will, it all has to end up in a process called probate court. Anybody ever heard the term probate court? Basically, the judicial application for the administration and distribution of your estate. It can be a long process. It can be an expensive process depending on various factors. And we'll talk about more about that, but that is the second option. A third option is called a revocable living trust. It's what my wife and I have. It's what our Free Will Baptist Foundation has helped hundreds and hundreds of couples with. A revocable living trust is simply a legal entity that you create while you are alive and healthy. You then retitle your assets into the trust. You as an individual or you as a couple, husband and wife, become trustees of the trust. Nothing changes in how you operate your day-to-day life. For example, my wife and I, our home used to be titled as Todd and Teresa Smith. Now it's titled as the Smith Revocable Living Trust with Todd and Teresa Smith as trustees. We continue to make our house payment. We continue to pay our property taxes. We continue to pay our house insurance. We continue to file our tax returns at the end of the year like we always have. None of that changed. But our trust owns our house. And when we die, does our trust die? No. It says disperse these assets to our intended beneficiaries, which are our children. My wife and I have 3 children, our 2 oldest serving as our successor trustees, and then they have the authority after our death to disperse the assets to themselves and to our children without the need for probate. And when those assets are funded into the trust, you avoid the probate. How many of you think it would be a good idea to avoid the probate process? We're going to talk about that tonight. If you'll open your book, and we're going to follow along inside the book tonight, talk about several things and allow you to fill in the blanks. But we live in what is called, and don't laugh, but we live in what is called a voluntary taxation society. That means that you and I volunteer to pay taxes. And I don't know how voluntary it is. If we don't pay them, we could end up going to jail. But what type of tax do we pay here in America? Well, several different types of tax. If you earn income in America, what kind of tax do you pay? Income tax. If you own property in America, unless you live in one of 5 states, and North Carolina is not one of them, but if you own a house, or you own a boat, or you own a car, or a motorcycle, or a trailer, an RV, what kind of tax are you going to pay? Somebody tell me. Property tax. If you go to the mall and you buy something for your kids or your grandkids, what kind of tax are you going to pay? Sales tax. There's another type of tax the government came up with. It is called capital gains tax. Basically, what the government says is if you make any capital gain, if you were wise and you invested and made an investment, and you made a profit off of that investment, then it is possible that you could face capital gains on that investment. The bottom line in plain English is this. You buy something down here, you sell it up here, and everything in between is a capital gain. Now, does the government want some of that? Absolutely. Currently, the minimum capital gains is about 15%. It can go as high as 28, 29%, depending on some various factors, but let's just use the 15% as illustration. Let's just say my wife and I, as a way of illustration, bought this cabin at the lake in 1970. And let's just say that we bought that cabin for $50,000 in 1970. Let's just say in 2016, we decide to sell that cabin, and we sell it for $150,000. We bought it for $50,000. We sold it for $150,000. What is the capital gain, church? How much? $100,000. What is 15% times $100,000? $15,000. That's what the government would want for that. Now, sometimes what people may commonly make the mistake of is they'll say, well, I don't want my assets to be probated. I'll just add my kid's name to my assets with me, and then when I die, they'll just get it tax-free. Is that right or wrong? Wrong. Because you see, here's what the government says. If my wife and I bought that house back in 1970 at $50,000, and then I put my kid's name on it, and then let's just say my wife and I die in 2016. My kids go to sell that house, and they sell it for $150,000. What did I just pass along? Because here's what the government says. The government says because you were on deed with mom and dad, we've got to revert back to what mom and dad originally acquired that property for to determine the cost basis in order to calculate the capital gains tax. We bought it for $50,000. They sell it for $150,000. The government says 15%. What did we pass along to our kids, even though we may not have intended to do so? A $15,000 tax. Now, I want you to circle in your books at the bottom of that page, stepped up cost basis. Because this information is worth you coming here tonight. The government says if you will allow your heirs to inherit what you will have, they will allow you to use the stepped up cost basis. So, for example, my wife and I, we've got the Smith Revocable Living Trust. Our trust says that our beneficiaries are our children. Let's say that we take that house and at the cabin at the lake, we deed it into our trust. We're trustees of the trust. We can continue to do anything we want to. We're 100% control of our assets. If it were your trust, you would have 100% control of your assets. Nobody could tell you what to do with it. You want to sell your assets, you sell it. You want to buy assets and put it into the trust, you can do that. You have 100% control. So we keep that house at the lake, and we let our kids stay there, and time goes on, and we die. Our trust says these assets are to be dispersed to our children. The government says because you children inherited that asset, then we're going to let you use the stepped-up cost basis. We're not going to take the value at the time that your mom and dad purchased it, but we're going to take the value at the time of death. In other words, we're going to allow you to step up the cost basis. So the government says that mom and dad died in 2016, and it was valued at $150,000. The kids sell it. They sell it for $150,000. What's $150,000 minus $150,000? Somebody tell me. Zero. What is 0 times 15%? 0. Did my kids have to pay any tax? No, and neither would yours. Now that is probably the number 2 reason why we should not put our kids' names on our asset while we are living, so that we don't potentially put them into a capital gain situation after our death. But second of all, turn the page. The moment that you and I put someone's name on something we own, then they become a co-what? Co-owner. Therefore, we potentially inherit anything that happens in their life. So let's just say that I put my son's name on my house. My son gets in an accident. There's a fatality. Somebody dies. My son gets sued. Of course, insurance is going to kick up what they can, but that's got limitations. And his name is on my house. Is my house now at risk? Very possible. What about, let's just say I decide to put my daughter's name on my bank account. I just say, I want her to be able to access this money when I die. I'm going to add her as an owner on my account. And so I end up adding her name to my account. Well, let's just say she's filing her tax returns and she messes up accidentally. She doesn't intend to, but she messes up. She gets audited, and the IRS says you owe us more tax than what you thought you did, and we're going to put a lien on your bank account. We're going to garnish your wages. Can the government do that? Absolutely they can. If her name is on my bank account, is my bank account now at risk? It is very possible. And I know we're in church and we don't like to talk about this, but we have to face reality. What about cases of divorce? Let's just say that I put my child's name on my asset, and then my child ends up getting a divorce. You hope that never happens. You pray it never happens, but it may end up happening. I'll give you a true case. There was a case in Alabama. There was a lady. She had a $280,000 CD. She thought in her mind, you know what, when I die, I want my son to be able to access that, so I'm going to put his name on the CD with me. It made sense. She wanted him to access the money. Turns out the daughter was indeed, the son, was indeed married and did end up getting divorced. The daughter-in-law filed for a divorce. The attorney for the daughter-in-law says, wait a minute, your husband was on a $280,000 CD with his mom, is that right? She said, yes. It went to court. Now, what did that mother do when she put her son's name on that CD? She imputed half of that CD to her son. Now, in the body of Christ, as Christians, we know what imputation is. Imputation is just basically an accounting term. It means to move from one side of the ledger to the other. When Jesus Christ came to this earth and died on the cross of Calvary for our sins, our unrighteousness, the unrighteousness of the world, was imputed to Him. He took upon Himself the sins of the world. When we accept Him by faith, that He is the true Messiah, and He is the true Son of God, then His righteousness is imputed to us. And we are justified in the eyes of God. That's what justification is, as if we had never sinned. Our sin was imputed to Him. His righteousness was imputed to us. When God looks down from heaven, He no longer sees that sinner, but He sees that saint that's been washed in the shed blood of Jesus Christ. Now that's what imputation is. It just simply means to move from one side of the ledger to the other. What did that mother do when she put her son's name on the account with her? She imputed half of that to him. Now she had a $280,000 CD. What is half of $280,000? $140,000. A judge upheld it in court and said half of his half belongs to her. Mother-in-law has to write a check to the ex-daughter-in-law for $70,000. Now, I know we're blood-bought, born-again Christians. I don't know if that had been a problem at your house, but that had been a problem at my house. We were at one of our Free Will Baptist churches, one of our Southern Free Will Baptist churches in Alabama, and there was a dear, sweet lady. She was probably about 89 years of age, maybe weighed 98 pounds soaking wet. And when we shared that story, she said loud enough so that everybody in the church could hear. She said, well, that wouldn't have been a problem at my house. I'd have just shot her. That's how people in the South handle things, right? We want to avoid those types of situations. What are other methods that people use? What's called POD or TOD. My banker friends know about that. It means payable on death or transfer on death. Basically what it means is that, you could put somebody as POD on your account, and then when you die, they can take a copy of your death certificate and they can take a copy of their ID, and then they would be able to access the money after your death. Therein lies the problem. They've got to have a death certificate. What if there's not a death certificate? What if someone has a stroke? They become incapacitated. Doctor says heart's good, lungs good, but it's going to take them a long time to recover. They've got to have somebody to access that money in order to be able to take care of that incapacitated person. So, of course, if they don't have the proper documentations in place, then they'll have to go to court and get appointed as a guardian ad litem on behalf of that person. In other words, POD and TOD, there is no death certificate in case of incapacitation, and therefore it doesn't cover incapacitation. That's why we believe, and the attorneys tell us, that beneficiary designation is the best way to get assets to our family. Now, let's talk about inheritance tax. I'm not going to spend a lot of time here, but there's another type of tax that people could potentially pay. It's called inheritance tax. Sometimes people call it death tax. Those terms are used interchangeably, basically a part of the Economic Growth and Tax Reconciliation Act. The government says if your estate is worth more than X amount of dollars, then we're going to tax it at, 35, 40%. Now, before you start writing your congressmen and your senators about this, the current exemption, 2016, is about $5.4 million. So as long as you're not worth more than $5.4 million, then you don't have to worry about this. If you're here tonight and you are worth more than $5.4 million, Pastor would like to talk to you after the service is over. And even there's a dual exemption. But can the government change that number and lower it? We're living with a government that is now $20 trillion in debt. Remember, it wasn't that long ago that the threshold wasn't $5.4 million, it was $600,000. And the government said if you're worth more than $600,000, then everything that you pass on to your kids, your estate is worth, then we're going to tax it at a certain percentage. Now remember, the death tax or the inheritance tax, it includes everything you've got. It includes your house, it includes your car, it includes your bank accounts, it includes your 401k, it includes your IRA, it includes your life insurance. In other words, you take everything that you've got and you add it up, and then that's what the government says. Now, somebody might say, well, I'm not affected by $5.4 million. But what if the government lowered it to $1 million? Well, let's just say the government lowered it to what it used to be, $600,000. You remember, it wasn't long ago, there was discussion about the $250,000 figure. You remember, if you were worth more, if you made more than $250,000, then you were considered wealthy. Those that were less were, and it actually went into committee discussion, never came out for a vote, to potentially lower this to $250,000. You might not be affected by $5 million. You might not be affected by $1 million. You might not be affected by $600,000. But the lower that number gets, it might start affecting more and more people. And of course, this is one thing that our foundation does is we monitor these types of things so that we can keep our people informed about these types of changes that are taking place. But let's just say the government lowered that number and you were kind of getting close to that threshold. Well, there are some solutions. One is, let's just say that you were getting close to that threshold, the government lowered it, and it became lower than what it is now. Then you can gift to your heirs, and it doesn't necessarily have to be your heirs. You can gift up to $14,000 a year without it being a taxable event in their life. We got anybody here tonight with their parents? Raise your hand. We got some kids here. Your parents can give you $14,000. How many of y'all think that would be good? Mom and Dad give you $14,000. That would be great, wouldn't it? We're living in a world today where God has blessed the medical field and we're living longer than we did years ago. Therefore, let's just say that you end up giving money away to your kids. Then you end up living longer than what you expected to. And then you need some of that money back. What are your chances, if you've given that money away, of getting some of it back? Somebody say zero. So the attorneys tell us a better way to get money to your children or your assets to your children is a revocable living trust. By the way, it is changeable. That's why it's called revocable. It is amendable. It's changeable throughout your lifetime. You, as the grantors, have the complete authority to change your trust, to do whatever you want to with it. Attorneys tell us that a living trust, it is smart, it is simple, and it is cost effective. Now, if you went out into the world and you went to an attorney and you said, I would like to go ahead and settle my estate now. I don't want my children to have to deal with this after I die. I don't want my estate to have to be probated. I want to be able to settle everything now, and I want to be able to get a comprehensive estate plan that's got a trust and all the documents that I need in life, in case of incapacitation, and after death for the distribution of my estate. Then what most attorneys, and this number will vary, okay? Please understand, this number will vary. But if you went out into the world and you ask an attorney to help you put together a comprehensive estate plan, it would cost you around $3,000. Now, I can tell you, I have talked with folks, and they've come up to me afterwards, and they said, man, I wished I'd have heard you. I was up in Virginia and talked with a couple, and they said, I wished I'd have heard you 2 years ago. We went out and did this, and said it cost us, $5,000. I was at Garner Free Will Baptist Church regarding the story I told you a while ago. An 82-year-old man came up to me a couple of years ago, and he said, I wished I'd have heard you a year before. He said, because it cost us about $4,000, and we're not even finished yet. But that's about what it would cost. My wife and I went to our attorney in Columbia, South Carolina. Our Free Will Baptist Foundation office is in Nashville, but my wife and I, we live in the upstate of South Carolina, the Greenville-Taylors area. And our attorney is Dan Felker. He's a Christian. He's actually the attorney that partners with our Free Will Baptist Foundation. But I told our attorney, I said, we need to get some things in place, we were thinking about these things. And so at that time, we still had one child that was a minor. We were concerned about what would happen to us if we died. And then we had 2 children that had already become legal adults at the age of 18, and we were concerned about making sure that they didn't have a lot of problems to deal with. And so the attorney said, well, I can do a will. And I said, well, if you do a will for us, it costs X amount of dollars. And then he said, and if you want me to help you probate that will, then he said, as long as everybody gets along. I said, how long does it take to probate a will? Now, it can take anywhere between 6 months and 2 years. In South Carolina, where I live, minimum 8 months. Because what has to happen? When you've got a will, announcements have to be put in the newspaper. Creditors and lien holders have got to have their opportunity to get their hand in their pot. Now, remember, there are 2 types of probates. There's what's called a summary probate, a simple probate. Most of the time when one spouse passes away, things are fairly simple. Oftentimes husbands and wives have things titled together. So we're not talking about that type of probate. What we're talking about is multi-generational probate. See, when mom and dad die, or an individual dies, and there's no longer a surviving spouse, and now everything is going to the children or the intended beneficiaries, and that's when things become complicated. And so I said to the attorney, I said, well, how long does it take to probate an estate? He said, everybody gets along, maybe 30 to 40 hours. And I'm thinking 30 to 40 hours, so that's a week. And he said, no. He said, you got to keep it open so long. And I said, well, let me ask you this. I said, is there an alternative? He said, yeah. He said, you can do a revocable living trust. We can put all the documents together with it, and it's a one-and-done thing, and you title your assets into the trust, and your assets don't have to be probated after death. And I said to him this question. I said, do you mind me asking you how much you make per hour? I want to ask you something tonight. And I realize this varies, but on average in America, depending on towns and geographical locations, but somebody share with me tonight, how much do you think attorneys make per hour? Just a guesstimate, and realize this is average, so it fluctuates, but anybody share with me, how much do you think attorneys make per hour? 300, 250. How much? Anybody else? 500. I was at one church one time, and this lady said $2,000. I said, that's a New York attorney. Average hourly rate in America for attorneys is $325 per hour. Now, let's just back it down to the 300 figure that you gave, which is pretty accurate. Again, that fluctuates, but let's just say that, so I said to the attorney, I said, everybody gets along 30 to 40 hours to probate, and you make $300 an hour. And he said, yes. What is $300 an hour times 40 hours? Somebody tell me. $12,000. What if he's able to do it in 30 hours? What is $300 times 30 hours? Somebody tell me. $9,000. Or he said, I can do a revocable living trust. He said the cost is around $3,000, and we can do it, and it's a one and done. And that's why my wife and I ended up choosing the revocable living trust. We went ahead and settled everything. We titled our assets into the trust. We are the trustees of the trust, and then our children are the successor trustees. Now, our foundation has been able to find a way to do that for less, but I'm just saying that's basically the average. Now, let's talk about powers of attorney tonight. Powers of attorney. And by the way, as I mentioned this morning, do bad things happen to good people? Absolutely. What are the limitations of powers of attorney? Well, one is it ceases at death. In other words, you might be the power of attorney for somebody in your life, or they might be the power of attorney for you, but that power ceases at death. In other words, they can't use that power of attorney after death to settle your estate. The other limitation of a power of attorney is incompetency. If someone is incompetent, they can't enter into a power of attorney at that time. And if you don't hear anything I say tonight, please listen to this. Probably one of the number one reasons for us to plan and make sure that that which the Lord has blessed us is protected is because of this situation known as guardianship. Oftentimes we think of guardianship, we think of minor children. If I die, somebody's got to be their guardian after I die. But guardianship does not only relate to minor children, it can relate to the elderly, or, whether they're elderly or not, those who may become tragically incapacitated. I'll give you an illustration. I think you have the names Bob and Sally written in your book, but I'm going to tell you a true story tonight about Charles and Carolyn. Charles and Carolyn, they were a Free Will Baptist couple in my church in South Carolina. Very faithful couple. They were at church for all the functions, and Carolyn cooked for the meals. Charles worked with the county. He was a tax collector for the businesses, and he was getting ready to retire. An ice storm came through South Carolina, and Charles and Carolyn, they had a little dog. Dog was inside the house, and he decided he was going to go to the kitchen, get a cup of coffee. He was going to let the dog out, so he raised the carport garage door. He got the cup of coffee. He went out to the garage, and the dog was walking around in the yard. Charles is standing right up under the carport, just waiting there and standing and looking at the ice, waiting down the limbs on the trees, and wondering when that ice storm might pass. And then Charles did this. Charles Richardson took one step out from under the carport. He heard a crack. He looked up. A pine limb broke off of one of the pine trees in his yard and came down and hit him in the head, immediately incapacitating him. Now, in a situation like that, Brother Charles was rushed to Augusta, to the hospital, to the trauma unit. Of course, he was ministered to by our family, ministered to by wonderful health and staff there at the hospital at MCG in Augusta, Georgia. But in this situation, now Carolyn is thrown into a life-altering situation where she now has got to provide care for Charles. In this type of situation, say Carolyn doesn't have anything in place. Charles is in a nursing home, and she is having to travel many miles back and forth between the nursing home and her house. She can't physically take care of him like she needs to, but she's going and visiting him at this 24-care facility constantly several times a week. After a while, she wants to sell the house to get closer to the nursing home in order to be close to Charles. So she goes to an attorney, and the attorney says, Carolyn, where's Charles? Now, let me ask you something tonight, church. In that type of situation, why would it matter where the husband is at? What's important? Why? Because his name is on the what? It's on the deed. Just because a person becomes incapacitated, it does not diminish their legal rights. Carolyn says, well, Charles is in a nursing home. He became incapacitated. I'm taking care of him. I'm going to provide everything. The attorney says, well, do you have something showing that you are his guardian? See, I got this one-page power of attorney when we lived in another state, and the attorney said, Caroline, I can't use this one-page power of attorney. Do you have something where the courts have appointed you as a guardian ad litem on behalf of Charles? Closing falls apart. Carolyn can't sell the house. She has to go to court and get appointed as a guardian ad litem on behalf of Charles. Now, church, this is a situation that you do not want to be in. What she basically has to do is she has to go and sue her husband in a court of law in order to prove that he is incompetent, in order to prove that she is competent to take care of him. Now, she has to hire an attorney for herself in order to prove that she is competent to take care of Charles. Remember what I said, just because Charles is incompetent, does that diminish his right legally? No. Guess what? He's got to have an attorney to represent himself, because he's got to have an attorney to make sure that whoever's going to be that guardian ad litem for him is competent to take care of him. 2 attorneys. How much did we say attorneys on average make? $300 an hour. That's $600 an hour. Guess who's having to pay that? Carolyn. Turns out she does get appointed as guardian ad litem. But then from that moment on, there is court supervision. There's attorney's fees. There's medical consultation. She can't spend more than X amount of dollars on him without going to the court and getting approval in order to provide care for him. And there's record keeping. There's an annual audit she has to go through. Listen, this that I am telling you, there was an estate planning attorney. His name is Monty Donahue. He has argued cases all the way to the Supreme Court. He came and met with us at our Free Will Baptist Foundation about a year ago. He said, because we are living longer as a society, he said the fastest growing cases in America is legal guardianship for adults. I have an article up here. I'd be glad to show it to anybody after the service is over. You're welcome to look at it. The Plain Dealer, Cleveland, Ohio. An article, and by the way, let's just say that Carolyn had died, and this happened to Charles, and let's just say he had a child. Well, that child might try to become legal guardian of that parent, but what if that child lived in another state? Then the courts is not automatically guarantee that they're going to appoint that child out of state to be the legal guardian of that parent. So what happens sometimes is, in some states, is they actually appoint an attorney to be the legal guardian of these elderly. This is an article here. There was a lawyer that had become the guardian for 210 adults. The title of the article, Lawyer is Guardian for 210 Adults. He was collecting fees from their estates, and some of them had already died, and he was still collecting legal fees from their estates. I'm not saying attorneys are bad. We work with good, godly Christian attorneys, and there are wonderful attorneys out there. And I'm not saying they're bad. They've got to feed their family like we do. But listen, I'm telling you, these are types of situations that can be avoided if we have the proper documentation in place. And one of the things that our Free Will Baptist Foundation is doing is that we are working with qualified Christian attorneys in states all over America that are helping us put together a comprehensive estate plan for our Free Will Baptist families and our Free Will Baptist couples. And I want to encourage you to write on that page, avoidable. Those types of situations are avoidable when you've got the Free Will Baptist estate plan. It's a very comprehensive estate plan. It includes a trust and all the documents a person needs in life in case of incapacitation. I want to move very quickly along. I don't want to spend a lot of time here. I've already mentioned probate. It is basically your default option. Somebody has a will. And by the way, somebody's got a will, guess what? It becomes a public document. You have a revocable living trust, it's a private document. Your family stays in control. Your revocable living trust doesn't have to be recorded at the courthouse. It is private. Nobody has to find out what you had and what you gave away. a will becomes a public document, anything that passes through that court system. But it is the default option. It's what we stick our families with. Who benefits? Well, creditors, lien holders, and attorneys. Announcements have to be put in the newspaper. Creditors and lien holders have to have their opportunity to get their hand in the pot. And, of course, when attorneys are allowed to probate those estates, then they benefit as well. What are the actual costs? If somebody had a will and that's all they had to settle their estate, Elder Law Solutions says that they charge about 7% of the value of the estate. AARP, which is a think tank for senior citizens, says it can cost anywhere between 5 to 6% of the value of the estate. So you think about, you add up in your own mind, I know you can't get an exact figure, but you add up in your own mind about what the value of your estate is. You got a house, car, maybe, land, bank account, whatever, and this is what AARP says, about $5,000 to $6,000 for every $100,000 value. Gerald Condon, who is an estate planning attorney, wrote a book called Beyond the Grave. Now, he has passed away. His son, Jeffrey Condon, has actually written a second edition of that book that's out now. And Jeffrey Condon, who worked with his dad for many years, he's an estate planning attorney as well, said they charge anywhere between 4 to 6%. Matter of fact, I've read the second edition of that book. You know what Jeffrey Condon says? Jeffrey Condon says attorneys will say to one another that probate is their retirement program. What are the 4 issues of probate? It can take time, 6 months to 2 years. The cost, it can cost anywhere between 4 to 7% of the value of the estate. Everything is public. And then there's the emotional toll. And then somebody in the family has got to handle this when they're going through emotional toll already. And that type of situation is avoidable with what our Free Will Baptist Foundation does to help our Free Will Baptist families and those that attend our Free Will Baptist churches. Now, as I mentioned already, our Free Will Baptist Foundation, we work with qualified Christian attorneys in states all across America. By the way, a revocable living trust will cross state lines. So let's just say you put together a revocable living trust in North Carolina. I hope you never leave this church. I'm sure a pastor wants to keep you here for a long time. But let's just say, Lord forbid, you ended up having to move out of state 5 years from now. Well, guess what? Your revocable living trust will cross state lines. By the way, let me mention this real quick. If you have a will and you own property in multiple states, let's just say you own some property in North Carolina and you may have bought a cabin in the mountains of Tennessee, or maybe one day you'd like to buy that cabin in the mountains in Tennessee or somewhere else in another state. If you have a will, ever how many states you own property in, that's how many states you've got to be probated in. The property in Tennessee would have to be probated in Tennessee. The property in North Carolina would have to be probated in North Carolina. If you have a revocable living trust, it will cross state lines. You can deed your out-of-state property into the trust. And by the way, it doesn't mean that you've got out-of-state property now. It might mean that you decide one day down the road to buy out-of-state property, and then at that time deed that property into your trust. If you've got property in North Carolina, if you've got property in 10 states, if you've got property in 50 states, and it's deeded into the trust, your trust will cross state lines and avoid a multi-state probate. Now, what our Free Will Baptist Foundation does is we work with qualified Christian attorneys, and number one, we provide all the legal documents. It is all the legal documents that a person would need in life in case of incapacitation and the distribution of their estate after death. We also provide lifetime support for our families, and we follow up with them annually with a call. And then when one spouse passes away, if it's a husband and wife, and one spouse passes away, then the surviving spouse can call the Free Will Baptist Foundation, and we will come out and be with that surviving spouse. And then when both parents pass away, or if you're a widow or widower or a single person and you pass away, then we would go out and be with your family and help them. Elizabeth Stansel, Brother James Stansel, I mentioned this to Preacher Jonathan earlier. Brother James Stansel was our North Carolina Free Will Baptist bookstore director for 40 years. A couple of years or so ago, I ended up helping Brother James Stansel with his estate plan. Our attorneys put the documents together, and we ended up meeting with him 1 year shy. 1 day later, Brother Stancil passed away, standing in his driveway talking with his trash pickup guy about the Lord. He had settled everything with the Free Will Baptist Foundation, got his assets funded into the trust. Guess what happened? Elizabeth Stancil, his daughter, was the successor trustee. She called the Free Will Baptist Foundation. A representative went out to be with Elizabeth, walked her through everything. Elizabeth didn't have to go hire an attorney. She was able to handle everything with our help. And her dad's life honored many Free Will Baptist ministries. And of course, you have what's called a successor trustee. If you have a trust, they are the person that would handle the distribution of your estate. And you kind of think about who you would want that person to be. Now, let's talk about funding the trust. Funding the trust is just simply a $10 legal word. It's just paperwork changes. Here's what you do. Here's a simple way to think about this. Think of your trust as a safe. You went to Walmart and you bought a safe and you brought it home. Who is the trustee of that safe? You are. You've got the combination. You can put anything in that safe. You can take anything out of that safe at any time you want to in your life. Your trust is a legal document, but it is very similar. You can fund or transfer your assets into the trust. It's simply paperwork changes. Now, everything that we have falls into two categories. And when I say everything, I mean everything. Spiritually speaking, obviously, it all belongs to the Lord. He blesses us with it. But legally speaking, everything that we have, it is either probatable or non-probatable. Now, non-probatable assets are what's called beneficiary assets. Those are things like life insurance, your 401k, your IRA. Those types of things, they normally have a primary and a contingent beneficiary on them, and those types of things are considered non-probatable. But everything else that we have, the house, the land, the cars, the tools, the jewelry, the bank accounts, certain bank accounts, and things like that, those types of things are probatable. And so the idea is that you can take those probatable assets and you can fund them or transfer them into your trust, just paperwork changes, and your trust, watch this, gives probatable assets a beneficiary designation, thereby avoiding probate. And again, you can have complete control of your assets. Things don't change in life. You continue like normal. When you die, does your trust die? No. So what you want to remember is funded assets avoid probate. Funded assets avoid probate. Now, this is a typical flow chart. You'll notice this in your books, a typical Free Will Baptist couple. They create their revocable living trust. They are joint trustees of the trust. They continue in life like they always have. They make their house payment, pay their house insurance, file their tax returns at the end of the year like they always have. They are joint trustees. Now, one spouse passes away, our foundation goes out to be with the surviving spouse. But then I pick on the husbands tonight. Statistically in America, not always, statistically in America, the husbands pass away first. Now, I hope my wife is not that happy when I die, as that lady is. But then when I die, my wife, it's already spelled out in the trust, she becomes the surviving trustee. No need to change that. The document states that when I die. And if you are a widower or a widow or a single person, then you would start right here. You would be the sole trustee of your trust. Then when you pass away, of course, the foundation would come out to be with your family, and then your successor trustees, those that you put in charge, and our foundation is not here to tell you who to put in charge or who to give your stuff to. You decide who's in charge. You decide who you want to get what. We're just there to try to help put some things in place, and then your successor trustees disperse the assets to your intended beneficiaries without the need for probate. Now, Mom and Dad die. Now it's time to disperse the assets. Let's talk about the distribution of your estate. Coming down to a close here, and then we're going to have some question and answer time. But let's just say you've got a responsible child. my wife and I, we've got 3 children. Now, let's just say you've got 3 children. Let's just say you've got $300,000 estate. That doesn't mean you got $300,000 in the bank. But if you add everything together, the house, the car, life insurance, everything together, then you got a $300,000 estate. You got 3 kids. That means each kid is going to get how much, church? $100,000. Well, you might have a responsible child. You give them $100,000, and they're responsible. And they're going to handle it. They're going to manage it well. You might have a wild child. Now, by wild child, I don't mean that they're bad, but they might be a spendthrift. Listen, I've got 3 children. I can give one of my sons, $20, and he'll probably have it in a month from now. I've got one child. If I give them $20, he's going to find a pawn shop, a Bass Pro shop. I mean, he's going to find a gun shop, a knife shop. I mean, he's going to want to spend it. So somebody might have a wild child, not necessarily bad, but that might mean that they might not spend money wisely. You might not want to give that child $100,000 all at once. You might want to state in your trust that you want to give that child $20,000 a year for 5 years. Or you might want them to have $10,000 a year for 10 years. I had an elderly deacon one time in one of the Free Will Baptist churches. He raised his hand. He said, what about $1,000 a year for 100 years? I said, that's up to you, whatever you want to do. But what about special needs? Let's just say there's a child that's getting medical assistance, or maybe a grandchild, or a special needs case, and they're getting medical assistance through the government. What are the rules of 2? Remember, they might be getting Medicaid or something like that, and then you die, and then that child gets $100,000 all at once. What's going to happen to that assistance that they're getting? They're going to lose it. And then what's going to happen when that's all gone? And then now they've got to try to get back into the program after they lost all of that. So another idea is that you could do a special needs trust within your trust and end up dispersing a little bit over time so that that child doesn't end up losing all of that you intended to go for them, and it can keep them under that threshold. What about Free Will Baptist Ministries? What about this local church? Listen, as I told you a while ago, our Free Will Baptist Foundation is not here to tell you who you should give to or who you want to be in charge. That's a prayerful consideration between you and your family. And we don't require this to help our families, but we say, one day, wouldn't it be wonderful if your life could continue to give to the ministry of this church after you passed away? In the Bible, the lost are pictured as goats, and the saved are pictured as sheep. When that goat dies, he dies. There's really no benefit from his life, not much benefit. But what can happen when a sheep dies? You see, that sheep gets sheared, and that wool gets turned into clothes. It is very possible that some of the clothes that you and I have on here tonight very well may be that a sheep has already died, and his life is continuing to give to us, even right now by providing warmth and clothing for us. As Christians, we are God's sheep, and our lives can continue to give on even after we die. Wouldn't it be wonderful if God's people would say, you know what, I'm going to tithe 10% on my estate. God's blessed me so much, and my kids won't mind if they get 90% and they give 10% to the Lord's work, this local church, maybe even Southeastern Free Will Baptist College. Again, you decide what's done with that. We're not here to tell you what to do with that, and we don't require that to help you, but just we say prayerfully consider the Lord's work, because even after you're gone, the work of this church is going to have to continue on to minister to the younger generation. And so we say pray about that. Why choose the Free Will Baptist estate plan? You've got protection from court-created guardianship, funded assets, avoid probate, and you've got the control of distribution of your estate. There's peace of mind. The choices, I'm not going to read all of this. It's in your book. You can't decide not to make a choice. Because if you don't make a choice and you say, I'm going to do nothing, then guess what you did? You made a choice. So the choices are there. You've got a will, or you've got the revocable living trust. And we believe that you are the best person to settle your estate. Now, let's talk about the Free Will Baptist estate plan. Again, it includes all the legal documents. I have here a sample of one of the binders. Matter of fact, we were at Faith Free Will Baptist Church in Goldsboro. Matter of fact, some of y'all are going to a ladies' retreat. You're going to be hearing Miss Brenda Patrick, Brother Dan and Miss Brenda Patrick, our Free Will Baptist Foundation, help them. We've helped Brother Jonathan's uncle, Brother Nate, and his wife. But this is a sample of one of the binders that includes all the legal documents. Includes the living will, the revocable living trust, the medical power of attorney, the durable power of attorneys, includes the transfer of personal assets. It includes all the documents that a person needs in life and after death. The attorneys have to do that. Legally, we can't do the legal documents, but we've got the partnership with the attorneys already. They're Christian attorneys. Number 2, the lifetime support. And then number 3 is the settlement at death. As I've mentioned already, we would go out and be with a surviving spouse, and there would be no cost to that surviving spouse, and then we would go out and be with the family. There would be no cost to that successor, trustee or trustees or their family after death. And so that is what our Free Will Baptist Foundation is doing. We're here to guide you every step of the way. Now, let me ask you this. In closing, who should have an estate plan? Who should be a good steward over that which the Lord has blessed them and prepare for end of life? Somebody tell me, who should? Everybody. You'll notice that I think it's on the back of your book. Anybody that might become incapacitated, anybody that's going to pass away, anybody who wants to keep the courts out of their business, anybody who wants to leave something for ministry, whatever you want to do, it's your choice with your assets, but we're here to guide you every step of the way. Now, I want you to notice there is an attendance form in your book. You may have filled out the top part already. If you haven't, I encourage you to do that. And we're going to do a little bit of a review. But before I do that, I want to stop right here. I mentioned to you this morning, you remember in service, I said, if somebody were afraid that they might have to go into a nursing home, what do? They take their name, their house out of their name, the primary residence out of their name, and it's got to be out of their name for 5 years. If it's not been 5 years, guess what? The government can do a 5-year look back. The government's going to try to get what they can on the front end before the person goes into the nursing home. The government's going to try to get what they can on the back end after the person dies. You see, it's after that person dies that the government can say, wait a minute, we spent X amount of dollars on mom or dad in the nursing home. Now we want some of that back. True illustration, Brother Pat Hall, Cape Fear Free Will Baptist Church. He had a couple in his church. One of them passed away. The husband had to go into the nursing home. They didn't have any children. And they had in their will, they just had a will, they had in their will that they wanted their house to go to their church. They wanted the Lord's work to be blessed. And of course, had they had children, this would have happened to their children. But what happened is, one passed away, Dad ended up into a nursing home. The government got what they could on the front end, but then on the back end, that house was supposed to go to Cape Fear Free Will Baptist Church. Brother Pat Hall and his church at Cape Fear Free Will Baptist Church got a letter from the government and says, you can turn it over to us or we're going to seize it, but we helped them in the nursing home, and part of that house, the majority of it, belongs to us. So guess what the government did? They had to turn it over to the government, and the government probably got about 90% of the value of that house, and Brother Pat Hall's church, Cape Fear Free Will Baptist Church, got hardly nothing. Now, that was because they had a will. If you have a revocable living trust, which is one of the documents in this binder along with many other documents, in North Carolina, what I'm telling you right now is true in North Carolina. You can take your home, you can create a revocable living trust, you can title your home into the revocable living trust. You are the trustees of the trust. If one of you passes away, the other one goes into the nursing home, guess what? In North Carolina, at this point, Attorney Patrick Neighbors, who is our partnering attorney for North Carolina, says the government cannot seize your property on the back end. with a revocable living trust, and that primary residence titled into the revocable living trust. Now, this type of thing is a huge benefit for you in North Carolina especially. But here's what I want to do is a review, and then I'm going to show you about a 2-minute video clip, and then I'm going to open the floor for answering questions, and I'll explain to you what the Free Will Baptist Foundation is doing for our families. Number one, if you own real estate, then I encourage you to check that line. You say, and that doesn't mean that you've got it paid off. My wife and I are still paying on our house, but we own real estate. Our house used to be deeded as Todd and Teresa Smith. Now it's deeded as the Smith Revocable Living Trust. We continue to make our house payments and do all those things like we always have. If you say, I've got health concerns, maybe I'm concerned, I become incapacitated, or if I had a stroke, or maybe you're already facing some of these issues. Maybe you've got family concerns, and you don't want to have to deal with those issues. Maybe you just say, I want to avoid probate. You can check that box, or maybe avoid guardianship. I don't want to have to deal with somebody having to go to court, even especially my spouse, having to put them through the situation of having to sue me just to become my guardian, and you can check that box. Or maybe you just simply say, I want to keep the courts out of my family business. Now, I want everybody to look this way. What our Free Will Baptist Foundation is doing. I told you a while ago that if somebody went out into the world and they got this done, it would typically cost about $3,000 to put a revocable living trust and all the documents that go with it. What our foundation is doing, we are a non-profit ministry, but we are paying the first $700 for each couple or individual to make this affordable for our families. Now, please understand this. I'm not up here selling you anything because I don't get one dime profit off of this. I talked with Pastor Jonathan before we ever came here. There are companies out in the world, and they do this. And their representatives will go to a hotel, and they'll try to get a bunch of people to go to a hotel. And then, number one, that representative that is sharing that information, every single person he helps, he's making money off of them. Number two, that company he works for is making profit off of that. Number three, when he goes out to meet with couples, he's there with an ulterior motive, and he's going to try not only to get their documents executed, but he's going to try to sell them life insurance or annuities or whatever else he can sell them. Our Free Will Baptist Foundation, we work with Christian attorneys. I am salaried just like your pastor. I do not make commission. Whether I help 5 people or whether I help 50 people, this is a ministry for me. We have helped over 13 couples in our Free Will Baptist churches. We've been to Faith Free Will Baptist Church. We've been over to Brother Jeff Jones' church at Hilltop. Many churches across this state already, and have helped hundreds of couples. When I come out to meet with you, I'm not there to sell you anything. I'm not going to try to sell you life insurance, annuities. I'm there to help get your documents in place. But we have to pay the attorneys. Legally, we cannot do that. And so what we're doing is we're paying the $700 up front, and that is leaving the cost of the estate plan at $2,300. That's not an annual fee. It's a one-and-done type of thing, and there's no type of annual fee that has to be paid. One of the things that we will do is there's basically 3 steps. And by the way, I realize that's a lot of money, and you might not be able to afford that. Let me say this. If this is going to take food off of your table, don't do it. If this is going to cause you to stop tithing to Wildwood Free Will Baptist Church and giving to the Lord's work, don't do it. But if it makes sense, you say, we've talked about this, we need to do something. Here's what we're doing. It's basically in 3 steps. Number one, if you fill out this form, and I'm going to give you a code in a moment just to put on it if you want us to help you. But we take that information, we give you a starter kit. It's on the front pew, and you can pick up one of those after the service. We will follow up. I'll give you a call probably within the next 24 or 48 hours, get some very basic information from you. When I call you, I don't need your bank account number. I don't need your Social Security number. We will never ask you any of that private information. The attorney doesn't need that private information in order to draw up documents on your behalf. The basic, simple information I'll be getting from you is your name, your address, date of birth, the names of your children, their date of birth. Some very simple things And then we have to get a $200 deposit in order to get the attorney engaged in the process. We have to have something up front to get that attorney engaged in the process. So initially when I call, you can do a $200 deposit by debit or credit card, whichever one. If you want to mail in a check, that's fine. That's the first step. The second step is the attorney calls you, and his profile is inside the starter kit. His name is Patrick Neighbors. He's a Christian. He would confirm your information. He would get any additional information, such as who you want to get what. Do you want to tithe to your local church? Do you want to, who do you want to give what? Again, that's not a requirement. If you want to, that's fine. If not, that's fine. We'll help you either way. You don't have to be a member at this church for us to help you if you attend here and you want us to help you. But the attorney is going to confirm, and he's going to get any additional information that he might need. The third step is he will get that binder to us, and I've got several of them in my car. I'll be meeting with some folks at Faith Free Will Baptist Church over the next couple of days, then going over to the Wilmington area, meeting with some couples there. I'll be sitting down with them. I'll be opening up, letting them look at the binder, letting them look at the documents, making sure everything's exactly like they want it to be. It says who they want's in charge. It says who they want getting what. Get the documents executed. And then, of course, at that time, when we deliver the documents, when we deliver the binder, is when you get an invoice for the remaining balance of $2,100. At that point, you don't pay me anything, but you can split it up over 12 months. We want to make this affordable for our young couples who are concerned about their children and who might become minor guardians. We want to help the middle-aged. If you're like I am, I've got kids in college, and that's expensive. We want to be able to help the middle-aged families. We want to be able to help the elderly who might be on Social Security, and we allow them to spread it out over a year interest-free. We've never charged a dime of interest. We don't charge late fees. And even in special circumstances, we have even helped some individuals by spreading it out longer. We work on those by a case-by-case basis. We don't want this to be something that is a financial burden to you. We want it to be a blessing to you. If you say, Brother Todd, this is something that makes sense to me, and I do want the Free Will Baptist Foundation to help me, and especially in North Carolina, if you've got a huge benefit, it could potentially be a six-figure savings depending on the value of your property, preventing the government from seizing it on the back end. I want you to write this code on your form, and then you would come up here at the end. There is a starter kit, and I thought I had one. Yeah, I've got one. There's a starter kit. It looks just like this. You would turn your form over and put it on the front pew, and you would pick up a starter kit. Inside of that starter kit, it's got a profile for the attorney. It tells you what the next steps are. But if you say, Brother Todd, we want you to help us, I want you to put FWB on your form. FWB on your form. Again, please understand, our foundation is not in this for a profit. I've seen the financial statement. We have to pay to make this possible for our Free Will Baptist Foundation families, for our couples and individuals. And by the way, somebody says, I've got a family member, or mom or dad, or somebody that needs to know about this. We have even extended this to non-Free Will Baptists if you've got somebody that you know. Now, I only go in Free Will Baptist churches because I'm an ordained Free Will Baptist minister, and it's a ministry for me. But if you've got somebody that lives in another town and they're not Free Will Baptist and they're your friend, your family member, by all means, we would be glad to help them. And you don't necessarily have to be a member, have already joined here. It's a ministry for us. I want to show you a 2-minute video clip and then have some questions, and then we'll close. Somebody says, well, what about, talking to somebody that might know a little bit more about this? Judge Philip Whitaker, he is a Free Will Baptist. He is an attorney. He is an ordained minister. He has served on some of the highest courts in the state of Arkansas, and he is on our Free Will Baptist Foundation board. And there's a 2-minute video clip that I'd like to share with you, and then I'll close it out with some questions and then turn it over to the pastor. But this is Judge Philip Whitaker.
Hello, my name is Philip Whitaker. Please allow me to introduce myself. I am a lifelong Free Will Baptist. I am an ordained minister within the denomination. I also have been blessed by God. I am a lawyer, and I've had the privilege of serving 19 years as a judicial officer in the state of Arkansas. I know that you've seen a presentation concerning the necessity and the urgency of some estate planning options. I would just like to address with you briefly my thoughts on this particular topic. First of all, let me tell you that in my experience as a judicial officer, I think it is essential that each home consider some estate planning. I know that you've heard some information about some trusts and how that can fit into your estate planning. As a judicial officer, I would strongly encourage you to give some consideration to the formation of a trust if it meets your particular needs. From personal experience, I can tell you that within my own family, my wife and I have developed trusts as an estate planning option for meeting not only the needs of the distribution of any assets that we might have to our children and our intended beneficiaries, but also to help extend the kingdom of God. So, give some strong consideration to the trust as an option that might meet your needs and what you intend to do, not only for your children, your family, and your beneficiaries, but how you can also distribute some of your assets of your estate to continue the ministry of Jesus Christ even after you've left.
Judge Philip Whitaker, very wise man, serves on our Free Will Baptist Foundation board. He has served on some of the highest courts in the state of Arkansas. But what I would like to do is now just open the floor, and I think we can conclude the video session, and then what I'd like to do is just come down here.